The Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, we are prepared to begin argument in our first case, United States v. Williamson. And Mr. Weston, when you're ready, we'd be glad to hear from you.
May it please the court. This case concerns not whether the district court analyzed juror bias, it did, but whether it applied the correct legal standard and analysis after finding deliberate concealment of material information during voir dire. The court found the jurors' answers were untrue and designed to avoid disclosure of a material issue, yet it treated that concealment as constitutionally harmless by focusing on the juror's stated motive and the strength of the evidence instead of the issues he was untruthful about. The court, one, failed to apply the intrinsic bias analysis, and two, the court misapplied the McDonough analysis in this case. And the case turns on whether deliberate concealment of material facts deprived the defendant of a fair opportunity to seat an impartial jury under the Sixth Amendment. Three of the district court's findings that were really important were, one, that he gave untruthful and misleading answers during voir dire. Two, that the concealment involved material facts. And more importantly, those concealed facts concern the jurors' own misconduct in law enforcement and drug investigations in a case where the defense challenged police credibility as the defense.
Isn't the question before us simply whether the district court abused its discretion in denying the defendant a new trial?
I certainly agree that abuse of discretion is the analysis that this court has to go through, but I think the
abuse of discretion with respect to the ultimate question of whether the district court abused its discretion in denying Mr. Williamson a new trial.
I do, Your Honor, and I think the court clearly abused its discretion when it did not conduct an intrinsic bias analysis in this case. You know, the court made the factual findings that the juror did all the things I've already talked about, that he concealed information, that it was deliberate, and that it concerned a material issue in this case. He made those factual findings, but he failed.
You know, in terms of the abuse of discretion standard, we normally think of juror management as something that is preeminently within the province of the trial court, and the trial court has a much better handle on juror selection than we do at this level. And at the heart of this would seem to be a credibility finding, and the district court here credited the juror's repeated assurances that he could remain impartial. And given the role that district courts play in jury selection, and given the abuse of discretion standard, and given the fact that a credibility assessment, which the district court was in the best position to make, why would we grant a new trial, and given the standard of review and given the credibility finding that was made?
Well, I think, Your Honor, and I think Porter versus White touches on it, but in a case where the person has already deliberately concealed information, and that information goes directly to a material issue, that can't be cured by a later, well, I can be fair.
Well, but this was, if your view was wasn't this case remanded to the district judge?
Well, the posture was, Your Honor, I didn't handle the trial counsel. I was appointed as appellate counsel I noticed the juror issue, and it was sent back based on an indicative ruling motion.
Okay, well, it was, the case was sent back. If it was as cut and dried cut and dried a matter, as you suggest, it would not have been sent back to the district court for further proceedings. You would have granted a new trial outright. But apparently by remanding, there was a judgment on the part of the panel that the district court's superior perspective was something that should be found out and added to the equation. And after the remand, the district court seemed to me was very, very conscientious about what this court had asked it to do. It didn't just snap off a finding. It, as I understand it, had an evidentiary hearing.
Yes, Your Honor. I certainly cannot disagree with the principle that this court gives large deference to trial court's findings in jury matters. The reason it was sent back in this case, though, was because it was never litigated at the trial level whatsoever. There was nothing even known about the juror. The only reason this issue came up is when I got the case on appeal, I recognized the juror's name from, I represented somebody else in this case long ago in the corruption that the juror was involved in. So the case was sent back. I don't think there's any indication that of what this court should do because it was sent back. And I don't dispute that the court held an evidentiary hearing. We actually had a 2-day evidentiary hearing. And I don't dispute the court did a very good job with its factual findings and, really analyzed the case well. But what I really dispute is that the court's finding that the court never analyzed actual intrinsic bias. And it made all the factual findings that triggered that. We asked the court to make the ruling, and instead it made the ruling based on, well, we think it was fair, or he did make this comment that he could be fair. But, I think that...
I think that sells the district court short. The district court honed right into the question of bias. You can't, by saying, well, there's intrinsic bias or whatever. The question was bias. And the district court says, I credit the assurances that the fellow could remain impartial. He said he was very indifferent to remaining on the jury, and that indifference was the very opposite of partiality. He said further that the jurors' previous brushes with law enforcement may well have created an aversion. It could go one way or the other. But he honed right in on the finding of bias, which was what I thought a remand was all about. And he made a judgment call in an area that is preeminently a one for trial court management.
And he's certainly allowed to make a judgment call, but I don't believe he analyzed the case under the right lens. If we look at, I believe it's the Conway case, and it talks about dishonesty is evidence of bias. And it cites the Burton case from the 10th Circuit for that. And so he was dishonest not only during the voir dire. The court found that he was dishonest at the evidentiary hearing about numerous material matters, about, whether he was a corrupt police officer, about whether he was involved in all of this Team Mingo stuff. So the court, found that he was dishonest. And once the court, under intrinsic bias, but it never did the intrinsic bias analysis, but once you find that a juror lied about material matters, then that cannot be cured by a simple assurance of I'll be fair. It's already happened. And when the juror was seated is what we need to focus on. At the time he was seated, he brought these prior, all this going on with him before, of he'd been accused of so many improprieties, to a case where that was the defense of improprieties of law enforcement. So, just him saying, I will be fair.
If there's a per se rule to the effect that you're arguing, why didn't the Court of Appeals in the earlier appeal just say what you just said? But that there was a per se rule, that there was no need for further proceedings. But the Court of Appeals had the chance to just announce that flat rule, but it did not. It sent it back for further proceedings. And in addition, if the question is ultimately one of abuse of discretion in denying a fair trial, what is a fair trial going to do? What is a retrial going to do? I mean, the evidence is of guilt is overwhelming. The jury heard eyewitness testimony of 5 different drugs transactions. There were physical evidence of drugs and firearms and ammunition. There was an admission of guilt in a jail cell call. That's got to factor into whether there was an abuse of discretion in denying the retrial. And in any case where a retrial is asked for, one of the practical questions you have to ask is, what good would it do?
So I'll answer your first question about the remand, Your Honor. There's a lot of the cases we see in the Fourth Circuit, they come and the court analyzes some of the facts and then sends it back because an evidentiary hearing was not conducted. That is not the posture of this case. This case was on appeal on other issues. I, as appellate counsel, noticed the issues that were never litigated in the lower court. So there was no record whatsoever to appeal to this court on this issue. So the remand was issued by this court before any rulings were ever made by this court. This court said, I sent it back for an indicative ruling, and I'd never even heard of that before this case. But there were no findings whatsoever by this court.
Okay, well, now we have the findings.
And we do have.
And the findings go to the question of bias. I mean, you say, well, there were no findings. We sent it back, make some findings. District judge holds an evidentiary hearing. Now we have the findings. And in light of those findings, we have to ask whether there was an abuse of discretion.
We do, Your Honor. And I'll go back to your last question, which essentially was harmless error. This court has never decided a McDonough or actual bias case on harmless error. This is a structural error. When you seat a juror who has these biases, this intrinsic bias, which the court made the factual findings, then that you cannot do harmless error. If you look at, I believe it is the Conway case, when we look at the fairness prong of McDonough case, it talks about dishonesty itself is evidence of bias. And that's
Counsel, can I interrupt there? I mean, I think that's right, that dishonesty can be evidence of bias, but it's not, it doesn't necessarily mean that the juror's biased, I think. And the district court could take that into account, as I understand it, but isn't required because it's dishonesty to strike the juror unless it finds actual bias, which the district court said it didn't, or unless it finds implied bias, which seems to be talking about relationships to the parties or to the litigation that would make it impossible for the juror not to be biased. And so I hear you. The juror was involved in some troubling stuff, to say the least. That's an understatement. But I'm not getting the per se rule that you're articulating, from, unless you're saying it's that implied bias from a relationship. I'm not seeing that in the case law. It seems like this is something the judge had the right to consider all the facts and make a call on, and you seem to think he couldn't have made the call he did as a matter of law.
Yes, Your Honor. I think that the issue really goes to is, the court can make these findings, it can do it, but what we need to look at is that In this case is different than the other cases where the court gets to make a determination, because where that comes from is these cases are where the person, well, maybe they made a misstatement at the voir dire. Maybe they said something they weren't so sure about. But this case is different because this case is deliberate concealment, and the court found deliberate concealment. And this case is different also because it is about a material issue. You know, somebody at voir dire lies about cheating on their wife. That has nothing to do with the case. In this case that we have, this juror lied about whether he was involved in this political corruption scandal, whether he was involved in drug buys that were illegal.
Well, I know all of that, but to follow up the question is, if he was dishonest, does that indicate automatically, for purposes, we're going to construct some per se rule that says dishonesty is automatically, per se, evidence of bias. And one of the points that the district court made is, no, it's not evidence of bias, because the juror, in fact, was indifferent about remaining on the jury. He wasn't anxious to remain on the jury. And that indifference about whether or not to remain on the jury would seem to me to be the opposite of partiality and bias. If the district judge had found, well, that dishonesty is related to his desire to remain on the jury, and his desire to remain on the jury is because he has a definite slant on this case or some kind of deep-seated prejudice, then that's one thing. But, you know, here, the district judge took that into account and saying, yes, I think he can remain on the case. I credit his assurances that he can remain impartial. He was indifferent about whether he could sit. And in the final analysis, I don't think that the dishonesty created the kind of bias that would be a disqualifying factor.
Can I answer, Your Honor? My time is up.
Yeah, you can answer. Do you want to answer in terms of rebuttal?
Just real quick, I'm asking the court to make a very narrow ruling, certainly not a per se rule that if you lie during voir dire, you can't be on the jury. A very narrow ruling that if you lie, and if you lie about a material issue, and also if that issue is related to an issue that comes up in the trial, then that is intrinsic bias. All
right. Any further questions here of Mr. Weston? Judge Gregory, do you have any further questions of Mr. Weston?
I don't have any questions.
Judge Quattlebaum?
No, I'm fine. Thank you.
Okay. All right. Mr. Hanks?
Good morning, Your Honors. May it please the court. My name is Josh Hanks. I work in the U.S. Attorney's Office in Charleston, West Virginia. The court is correct, and the discussion so far has been correct, that this all comes down to the trial court's discretion and its credibility findings as to the witnesses and the evidence that were put before it. It sounds to me like what the appellant is actually arguing for is a new kind of bias. Actual bias is defined in case law. Implied bias is defined in case law. There are references to inferred bias, which is discretionary. And now he's asking for this intrinsic bias, which would be a completely new animal. And you know, it's hard to even respond to that. What we have here is a juror who admittedly lied or failed to reveal matters that happened 10 years before. And we'll concede it was material in the sense that it warranted under McDonough an evidentiary hearing. Judge Copenhaver conducted that evidentiary hearing. He examined the juror. He heard testimony from other witnesses. He reviewed all the documents, and quite frankly came to the conclusion that under McDonough, which also says, hey, the motive of the lie has to go towards some aspect of partiality or impartiality. And Judge Copenhaver, quite frankly, reasonably found that it's
So
understandable why they got it.
counsel, can I ask you something about that? Yeah, I'm just curious. I mean, I don't know that this would make it an abuse of discretion, but the language does talk about partiality and bias, which is it seems to be talking about having favoritism for one side over the other. Um, you know, this juror, said he didn't have that, and the district court said something that makes sense to me. It could go either way in terms of who it might favor. But can you have what if could a court make a conclusion that that the conduct of what this juror did back with the team Mingo combined with his misrepresentations just makes him so so adverse to the judicial process that he shouldn't be on the jury? I mean, he's not necessarily favored one way or the other, but he's just inherently corrupt so that you can't count on him to follow the law and the evidence. Is there anything like that? I mean, it might still be an abuse of discretion, but it's a little bit different than bias, if that makes sense.
I think a court, to answer the question quickly, I think the court could make that. It's within the court's discretion, and that's the category of inferred bias, where the appellate courts have said, hey, sometimes the circumstances don't support actual bias, and they don't have implied bias, which are per se rules, but we're going to affirm a district court exercising its discretion on an inferred bias. So I think if you have a case where the judge is just uncomfortable with whether the juror could be impartial based on some conduct in the past or history and characteristics, I think this court and virtually any appellate court would find that's within the court's discretion. However, in this case, it's quite unclear what exactly this juror was involved in. The facts that are asserted in the appellant's brief are largely from newspaper articles, unchallenged civil complaints, hearsay statements. The fact is, he was in fact served with a target letter. He was interviewed. As the district court found, he successfully disputed the allegations and he was never charged. So this case doesn't fall into what Your Honor is talking about as a hypothetical. In fact, the district court really only referenced all of those allegations to make the point that it was unreasonable to think that the juror just didn't recall that this happened. It's like, you've been served with 3 civil complaints. You were interviewed by the FBI. Don't try to tell us you don't remember this. But the judge quite reasonably said, well, I understand why you didn't want to bring it up, because this is a horrible, embarrassing situation that you didn't want to relive again in front of this trial. So I think, yes, a court could be affirmed in using that inferred bias analysis.
But counsel, doesn't that conclusion that the court made itself bring up a problem with, that is, a juror, and that's what a lot of times, I've tried a lot of jury trials, you're trying to see whether or not there's something in the case that makes the juror uncomfortable. And the judge basically found an uncomfortable point. As a matter of fact, he made it mentioned the motive. He said, well, I think this is something that he's just a version of something he didn't want to bring up in his life and things like that. That has an impact in terms of not a bias in a sense of left or right, one or the other, but a bias in the sense that it's something that just brings back an emotional type thing that has an influence. You don't think that there are situations where someone did not counterfactual, didn't mention something because it was traumatic for them, and then you find out later that traumatic incident has an impact on the evidence that was in this case. That's not necessarily a bias one way or the other, but it is something that impacts a juror being independent or being detached from something that's not going to be on the jury box or before them. And that, don't you think that the implication in terms of a juror, would you want a juror like that? I mean, I'm not talking about it. Didn't that something of what the judge found, that it was something about that incident that made him not want to tell it? Is that right? Let's start right there. Am I correct about that?
Yes, it's very clear the district court found he did not want to talk about what happened 10 years earlier.
All right, don't you think that's evidence that that's something that's impactful on their mind in the sense that, and then we found out this case, this is not a per se case at all. This is one where we're talking about things arose in this case that, as counsel said, Mr. Weston talked about, that implicates and brings back to memory, if you will, perhaps, and or relatedness to that. Was
Okay.
it not? So I mean, you can't find these things, then have the discretion just to say, nope. That's what abuse of discretion is. I mean, discretion is you consider all those things, you've done that, but if you then find things that are related to that and then find the opposite, don't you think that's a problem?
Well, again, it's within the court's discretion. I mean, I think that if the court makes findings that the judge believes that the juror is going to be so emotionally attached, but not enough to be an implied bias, the judge could make a call on that. But it's not an abuse of discretion to go the other way. For one thing, this premise that the trial defense theory involved an allegation of corrupt policing is simply not in the record. When you look at the record, when you look at the cross-examination and direct testimony of the case agent, and when you look at the closing argument of counsel, the defense was credibility of the CI and the fact that a federal judge had found that the case agent in an unrelated case had misled a magistrate, state magistrate. There were no allegations of corruption in this case. There were no allegations of manufactured evidence, nothing like that. So it's an overstatement to claim now that the defense theory at trial was corrupt policing. So therefore, if there was corrupt policing 10 years ago, we have this emotional connection that creates a bias that the district court must find, or that this court would overrule the court's discretion to find that there was no bias. It's just simply not supported by the record.
Counsel, let me ask you this. How do you think you make the point, and I think quite correctly so, that the evidence of the defendant's guilt here was overwhelming, because you not only get the eyewitness testimony of these drug transactions and the physical evidence of the firearms and drugs and ammo, but you have here an admission of guilt in a jail call, and the admission of guilt goes to the drug transactions. So how does the evidence and the overwhelming nature of it factor in to the abuse of discretion standard? It's a matter that a court in the exercise of its discretion can take account of.
Is your question, could the trial court take consideration of that?
Yeah. Mm-hmm.
Absolutely. I mean, there's really no limit on what the trial court can consider. I mean, that's the judge that's sitting there in the room, watching the witnesses, looking at the evidence, making those calls. So absolutely, that could be.
So you're saying that no matter what the bias may or may not be, when you go back and consider it, if it was overwhelming, like, well, no juror would have made any difference. You said that's a factor in determining that can be the factor.
I think that would be that's not going to be a factor if you have actual or per se bias. Like, I agree that if there's a clearly biased juror, we got a problem. But when you're talking about the nuances of whether some vague speculative thing is hanging out there that doesn't really clearly affect whether the juror is biased, as you say, left or right, I think the follow-up, the fairness of the trial analysis certainly could include the weight of the evidence.
When we have these Rule 33 motions for, I think maybe I've got the number wrong, but when we have these Rule 33 motions, there's always one of the factors in whether to grant a new trial or not is the strength of the evidence and what was the impression of the prior trial. And if the prior trial was one in which the defendant had a chance to put on his case, if there was no curtailment of cross-examination or any of the other panoply of rights that a defendant has, and if the trial was fair and the evidence was overwhelming, isn't that something that could factor into the judgment of the district court as to whether there was in the abuse of discretion standard with respect to the denial of the new trial? I mean, how could that not figure in to, was a new trial by its very nature is granted when there is something seriously wrong with the old trial. But if you have a fair trial in terms of the rights that defense and his counsel was able to exercise, and you have just an overwhelming amount of evidence, that can be one of multiple factors. It's not.
I agree.
And in some cases, the evidence could, I mean, the error could be so serious that you will say, well, given the error, it couldn't possibly be a fair trial. But in most cases, where we're dealing with a Rule 33 or whatever motion for a new trial, they always mention as one of the 4 or 5 factors the strength of the evidence, don't they?
That's correct. Yeah. And I don't think it's impossible to overcome that. I mean, if you had...
can you cite a case where we're dealing with the question of bias of a juror, and that was the court rule that way, that it was solely because, not solely because, but a large part of it was that the case was weak before the jury?
I don't recall one in my
I don't
research
either.
where the case... Yeah.
I don't either. Yeah. Because it's like you're dealing with a Batson question, and the juror was not honest about it, whatever. Again, just hypothetical or counterfactual here. And you go back and say, well, yeah, well, he was, but, that's the way he grew up and blah, 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 and all those things. But it doesn't matter because the case was weak anyway, so any juror would have found. You think that would be appropriate?
When you say the case
Going
was...
back, you found that there was prejudice, racial prejudice in that sense, and on the Batson the question should have been granted, the motion, and then you go back and review it and you find out, oh yeah, it was, but my goodness, yeah, you shouldn't have said it, it probably is, but it doesn't make any difference because it was overwhelming evidence. You think that would be the law?
As I stand here, I don't know. I did not research this under a Batson theory. I did find a number of...
Any theory. Mine wasn't just Bat. My question to you was any. This is just my counter. Don't try to limit it to that. I mean, you didn't find any case on any ground for questioning the challenge of the juror. I'm just talking about now this one. You think that would be appropriate? I'm just trying to see how important a jury trial is. I mean, our founders thought it was important to put it in the Constitution. It didn't talk about how strong or weak your case is. It says that you have a right to that. But go ahead.
Yes, I think obviously the jury trial is the end all be all for our criminal justice system, but also the finality is an important thing that the Supreme Court has recognized, and that's why so much discretion and so much weight of the evidence type analysis is approved.
One of the things is, first of all, this is not a Batson case. There's not a question of racial prejudice that I know that has been brought up in this situation. And the Batson analogy, which my friend puts forward, actually goes to prove your point. Because in that case, you have the finding of actual bias. That the thing was, the Batson finding was made that you could not treat the participants in the trial equally, or you could not view a defendant of one race in an impartial matter. So you have the finding of bias, but that's the thing that was absent here. It wasn't the finding of bias. There was a very different finding, which was that the individual could be fair-minded. in a Batson finding, there's no way that the individual could be fair-minded or unbiased in any trial in which any person of any race was involved. So that gets back to Judge Quattlebaum's point, is that as a per se matter, dishonesty is not bias itself. You see how different this is from the Batson?
I do.
When the Batson analysis, it's not a Batson analysis, it's a counterfactual, but it missed the mark. First of all, you wouldn't be back there if the judge had ruled in favor on the Batson issue. The question there is whether or not, in fact, the judge found whatever the juror said, maybe dishonestly. For example, not that I hate white people or I hate Jewish people or I hate black people, whomever you want to, but the fact that they lied about something in an incident that was involving something that related to race. And the judge says, well, that was an incident you didn't talk, but I don't think that bothered you in terms of that. So it's not talking about a case where you found that. So the question is whether or not it should have been granted in that counterfactual. So it's still a question of saying, well, the person said they're okay. They had that incident with a person of another race, but I don't think that would bother them. They said that it was just a bad day and they're fine now, have no bias. So that, of course, you would say is just abuse of discretion, right? Totally. Even though they didn't tell the truth about an incident about, it was a pretty racial thing. He remembered it, matter of fact, and that kind of thing. So, right? It wouldn't matter.
No, I'm not saying it doesn't matter. I understood your question to be to test the outside limit of how relevant is the strength of the case. And so I think that if in your counterfactual, or if there's a circumstance where after trial it's determined that one of the jurors, was a flaming racist and lied about it, or that they were the ex-spouse of a witness, or something that's a clear actual bias, I think that at that point, a court is going to, at the district court level, quite frankly, is going to give a little less weight to the strength of the evidence in the case. But it starts, though, with the court's discretion at the trial court level. And in order to prove an abuse of that discretion, the burden is pretty high on the appellant. And in this case, it's not black and white like that. It's not clear cut. It's speculative at best as to whether this juror's experience 10 years before may have potentially had some impact on impartiality in a case involving people he didn't know, a different court system than he'd ever been in, a different county. There's just simply no overlap between them. So our position is that the district court was quite reasonable and did not err, clearly or otherwise, in its factual findings, and just would ask that the denial of the motion for new trial be affirmed.
Your time is about up. I'm going to ask Judge Gregory if he has some further questions of you. If he does, we'll keep you up until those questions are answered.
I have nothing further.
Judge Quattlebaum, do you have anything?
I'm fine. I have no other questions.
All right.
Thank you.
Mr. Weston, I think you have 3 minutes for rebuttal.
Yes, Your Honor. I'd first like to address the intrinsic bias issue, and I take issue with the government saying that we're asking the court to try to create some new type of law. If you read Porter versus White, which is cited in our opening brief, it clearly lays out that law. Now, the government chose not to respond to that in its reply, in its response, but it's clear that case lays out intrinsic bias. And in that case, they did not overturn because in Porter, they said, we decline to infer bias solely because he failed to disclose information in response to 3 voir dire questions where the district court found that the juror did not repeatedly lie or intentionally conceal material information. In this case, the court made the factual findings that the juror intentionally lied and that he concealed material information. So we're not asking to ask the court to make any new law. We're asking the court to apply Porter in a very narrow fashion. And that narrow fashion arises because this is a very unique case. You know, this is a case where we have a law enforcement officer who the court found, you know, he obstructed a federal investigation into drug charges about this juror. And then he sat on a case where, and I take odds with their description of what this case and the defense was about. The defense of this case was that the police officer who did this was not honest about things, that he was found by another federal judge in the same district to have lied on a search warrant in order to get a search warrant. He said a drug delivery occurred, but it did not. And he was impeached by that at trial. So the jurors listening to this, knowing his own accusations against him, and he sees that through that lens when they're making that defense. And the further defense was that the informant had stolen buy money, which violated his agreement with the government, and that stolen buy money, and the officer in charge.
I understand all that, but I think what you're saying here is exactly the kind of thing that should be brought before Judge Copenhaver, that was brought before Judge Copenhaver, and that he was going to make a finding of. I mean, it seems to me what you're saying is that you don't like the finding that he made. You think he should have made a different finding. That's okay. I mean, it's a fair point. But the point was he had the discretion to make the finding that he made. And, you know, it seems to me made some good arguments. I hope you made them before Judge Copenhaver. I'm sure you did. But the whole thing does seem to me to bottom out on the fact that the court was asked to exercise his discretion to make findings, and the court did that.
I'm out of time. May I respond, Your Honor?
Well, you did. You see, you took 17 minutes for your opening statement, and that's fine. But then you only have 3 minutes for rebuttal. Now, you go ahead and respond, but if you could please make it brief. But I'd like to give you the chance to respond.
Certainly, Your Honor. The court, I'll be very quick and I'll be narrow. The court abused its discretion when it did not address the actual bias that is intrinsic when a juror lies about a material issue, and that material issue is also a factor in the trial. And harmless error cannot cure that, the facts of the case. It is a structural error. We pointed that out to the court in a long cite, and the court said, well, structural error doesn't matter because I don't find bias, which is a little circular. But it is a structural error that when a juror lies, when they are dishonest intentionally, then that is bias. The court made the factual findings, but it abused its discretion when it refused to address the actual and intrinsic bias.
All right. Well, thank you. Judge Gregory, do you have any further questions of Mr. Wilson? Judge Quattlebaugh? All right. We thank you both, and I'm sorry that we can't come down and recounsel, but that doesn't diminish in the slightest our appreciation for the arguments that you've made. And Mr. Weston, I see that you're court appointed, and I'd like to express the appreciation of the court for your argument and the fine job that you've done representing your client.
Thank you, Your Honors.
All right, we will move directly into our next case. All right, Mr. Weingrad, we'd be happy to hear from you, sir.
Thank you, Your Honors, and may it please the court. The opening round of briefs in this case focused on whether this court's decision in Salazar could be reconciled with the Supreme Court's intervening decision in Simonelli. But the Supreme Court's more recent decision in Cousisis rejected our reading of Simonelli, which means that Salazar remains the law of the circuit under which my client's conviction is a crime involving moral turpitude. So today I hope to instead address the issue raised in the supplemental briefs, which is whether a Class 1 misdemeanor in Virginia is a crime for which a sentence of 1 year or longer may be imposed. We contend it is not for two reasons. First, Congress intended this provision to apply only to crimes that are themselves punishable by 1 year or longer, or what Virginia and most states classify as felonies. And second, the maximum sentence for a Class 1 misdemeanor is 12 months, and the Court of Appeals of Virginia held in Belcher that a person convicted of such a crime cannot legally be sentenced to 1 year. Now, on the first point, the government is wrong to contend that this court already rejected the argument in Ortega-Cordova. The issue in this case was not briefed in Ortega-Cordova. I represented the petitioner in that case. Shortly before oral argument, I discovered the legislative history on which we rely in this case. So I alerted the panel to it in a 28J letter and specifically asked it not to reach the issue so that it could be resolved in this case. If an issue hasn't been briefed before this court, anything this court might say about it is presumptively, if not necessarily dicta, because it would not receive the court's full and careful consideration, and it would not impair the analytical foundations of the holding. And as importantly, when this same scenario happened in Chavez, this court did not deem Ortega-Cordova to have resolved the question. This court instead declined to reach the issue because, again, it had not been briefed. So the point being that if the language in Ortega-Cordova was truly controlling, Chavez would not have declined to reach the issue. It would have said that the argument was foreclosed by Ortega-Cordova. So Chavez only confirms that the language in Ortega-Cordova was dicta. Now, on the merits, I recognize that courts typically do not begin their analysis with legislative history, but I would be remiss not to note that this is a case where the legislative history shows us precisely what Congress intended. Before voting on the language at issue, members of Congress were repeatedly told that it would only apply to non-citizens who had been convicted of a felony crime involving moral turpitude. The committee report accompanying the original bill twice referred to felony CIMTs. Members of both parties said on the floor of the House that it would apply to felony CIMTs. And after the bill was referred to the Senate, a summary in the congressional record also said that it would apply to felony CIMTs. So the point, Your Honors, is that while legislative history cannot trump the text of a statute that's only subject to one interpretation, the very existence of this legislative history demonstrates that the statute isn't subject to one interpretation. Because if the only way to read the statute was the government's way of reading it, this legislative history simply would not exist. So I think the true question for the court is whether it's possible to read the statute in a way that's consistent with the legislative history. And we believe that it is because from a grammatical standpoint, the statute can be read two possible ways.
It seems to me that one of the statutory points that doesn't help you out is that the statute is written in the injunctive. It says a sentence of 1 year or longer. In other words, if either one of those conditions is present, that's what that suffices. And so this isn't longer than 1 year here, but you have a situation where the sentence is a maximum sentence of 1 year. And if either of those things is present, the statutory language would appear to control. And I think the Seventh Circuit agrees with that. And I think, that overturning a precedent of the court, which you can try to explain it away and say it's dicta, but when you read Ortega-Cordova, it seems right on point, isn't it?
Well, I think that's because Your Honor is assuming that the statute refers to the maximum possible sentence. And our entire argument is you don't have to read the statute that way. We read the statute as referring to a single set of crimes for which the sentencer has discretion to impose a sentence of either 1 year or longer than 1 year. So to see why our reading is grammatically possible, just consider the following question. Is Domino's a restaurant where customers can order pizza or sushi? Now, the answer to that question could be one of two things, because it depends on what information the speaker wants to elicit. The answer would be yes if the speaker wanted to learn whether Domino's sells either pizza or sushi, but not necessarily both. But the answer would be no if the speaker wanted to learn whether Domino's offers a choice between pizza and sushi. And here as well, Congress could have been referring to a crime for which a sentence of 1 year could be imposed, even if a longer sentence could not be imposed. That's what the government thinks. Or grammatically, Congress could have been referring to crimes for which either a sentence of 1 year or a longer sentence could be imposed.
Well, the statute is may be imposed. I mean, we're not talking about some mandatory minimum or something. We're talking about a statute in which a sentence of 1 year is possible. And I don't know how you read the language for a crime 1 year may be imposed. It doesn't mean that the sentence of 1 year has to be imposed. It says simply that it may be imposed.
We've never argued that this language requires a mandatory minimum. Our argument is that this language refers to crimes for which a sentence of both 1 year and longer than 1 year fall within the statutory range. And I would add that from a textual standpoint, the very phrase, a crime for which a sentence of 1 year or longer may be imposed, is a phrase of art that any reader would associate with a felony. So, for example, imagine a job application.
Yes, but that's not the way it's written. It is a conviction of an offense. It doesn't say conviction of a felony offense. The word felony doesn't appear there. I mean, it seems to me, and I don't blame you for resorting to the legislative history, but I just wonder whether we can really call upon the legislative history to do the job for us when the statutory language is as clear as it is, and when it's written in terms, when there's both the disjunctive or in the statute, and it's written in terms of what may possibly be done, what may be imposed. And those two things, among others, make it a bit of a hurdle for you.
Your Honor, 4 circuits have described this statute as applying to felony CIMTs. Our argument has never been that the statute refers to a felony, and Congress had good reason not to use the term felony because some states themselves don't use the term felony. New Jersey and Maine just classify crimes by degree. So if it used the term felony, it would have been excluding serious crimes in certain states. But the point I was making is that this phrase is a phrase of art. If a job application asked prospective employees whether they had ever been convicted of a crime for which a sentence of 1 year or longer may be imposed, I think the vast majority of people would understand that question to refer to a felony. Now, again, we recognize that other provisions of federal law define a felony as a crime punishable by more than 1 year, but many states and legal dictionaries define it as a crime punishable by 1 year or more. When this statute was enacted, yes, Your Honor.
Can I interrupt you? I mean,
Certainly.
I see your point that you could look in isolation and think that might have been, generally referring to felonies, and folks might think of it that way. The trouble is that Congress is kind of all over the place with this how they describe things. I mean, we got 1182A and 1227A that are both dealing with crime involving moral turpitude, and one applies to sentences of a year or longer, and one says one says only if more than a year. So why is that the case? I mean, I'm not sure why, but it kind of belies, it seems to me, the fact that we can just say, hey, they must have meant felonies. We got felon in possession statutes that are clearly talking about more than 1 year. And we got the rule of evidence that talks about impeachment, and it's crimes of more than 1 year. So Congress knows how to use those words when it wants to. Yeah, I'm kind of sympathetic. I can't make sense of how all those things are, but I really have a difficult time understanding how we can go beyond what the words seem to me to pretty clearly say.
Your Honor, our point is that when it comes to describing a felony, the phrases more than 1 year and 1 year or more are often used interchangeably. I was starting to say, at the time the statute was enacted, Brian Garner's Dictionary of Modern Legal Usage defined felony as a crime punishable by imprisonment for a year or more. So did a number of states, including Georgia, Illinois, Kentucky, Tennessee, Wisconsin, and New Mexico. And I think this actually matters because the member of Congress who proposed this bill, the original language, he was from New Mexico. His name was Stephen Schiff, and he served as a prosecutor for 2 decades before being elected to Congress. So he was undoubtedly familiar with his own state's definition of felony, which again was for a year or more. And not only did Mr. Schiff initially propose the statute at issue in this case, but he was one of the managers in the conference committee that produced the final text of the Anti-Terrorism and Effective Death Penalty Act, which is the bill in which this language was ultimately enacted. So the member of Congress who drafted the language in question and likely had it inserted into the bill in which it was enacted almost certainly understood the phrase 1 year or longer to be shorthand for a felony. But again, to be clear, we do not argue that the statute only reaches crimes that are classified as felonies under state law. Our argument is that the statute only reaches crimes for which a sentence longer than 1 year may be imposed, which are generally classified as felonies. And again, to Your Honor's question, it is true that Congress has been more clear in other statutes in defining a felony. But our entire argument is that the only thing that is clear about the statute is that it could have been written more clearly. If Congress wanted to achieve the result that the government wants, it could have simply referred to a crime for which a sentence of 1 year may be imposed. Or it could have referred to a crime for which the maximum sentence is 1 year or longer, similar to how it did in 1182 in the petty offense exception. So again, our point is simply that this statute can be read 2 ways. And then when you look at the other things like legislative history and the structural anomaly that the government creates, that tips the scale in our favor. And if I could just address that structural anomaly.
Let me just say one thing. I hear your point, but you just have 2 different hurdles to overcome. Number one, it's a hard case to make that legislative history takes precedence over the plain meaning of statutory text. And it might if the statutory text was genuinely ambiguous, but frank to tell you, I don't see that the text itself is ambiguous, and as Judge Quattlebaum said, and it's hard to see if the text itself is apparently clear, as the Seventh Circuit has said, to have the legislative history override that is a big step for us to take. And that would be particularly in the case where we are asked to I think, override the plain statutory text, but also to override one of our prior precedents in Ortega-Cordova, which seems to me directly on point. So we're asked to overturn one of our own precedents, and we're asked to overturn clear statutory text. And that's a tall order, is it not?
Well, as I already said, Ortega-Cordova, that language was dicta because this issue was not before the court in that case. So all the arguments that are in front of this panel were not in front of the panel that decided Ortega-Cordova. And as for whether this language is ostensibly plain, if it was so plain, I don't understand why 4 circuits would have described the statute as applying to felony CIMTs. And Judge Wilkinson, I would also note that Your Honor, in your concurring opinion in the Lockhart case in 2020, you also described felonies as applying to crimes punishable by 1 year or more, not simply more than 1 year. So again, the point is that courts interchangeably use the phrases more than 1 year and 1 year or more when it comes to describing a felony. So I think that itself creates ambiguity. I mean, and also with the legislative history, again, this legislative history wouldn't exist if the statute was only subject to one interpretation. I think we should presume that members of Congress are able to read the statutes that they enact. And if multiple members of Congress said on the floor of the House that this statute applied to felony CIMTs, then clearly the statute is susceptible to that interpretation. And to the extent the court finds that there is ambiguity, we would ask the court to adopt our reading under the immigration rule of lenity, which remains in force now that Chevron has been overruled.
Thank you very much. And you also have some time for rebuttal. And if either of my fine colleagues has questions for you, or Judge Gregory?
No questions.
Judge Qualaba? All right, thank you very much. As I mentioned, you've got some time for rebuttal. Mr. Was it Ramnitz?
Yes, that's correct.
Okay, let's hear your side of it, okay?
All right. May it please the court, Your Honors, Tim Remnitz on behalf of the United States Attorney General. My understanding that petitioner is waiving his arguments pertaining to the CMT on his challenge to Salazar. So I'm not going to address those arguments. I'm just going to focus on what he says is his remaining argument that he's not waived, which is the 1 year or more issue. And the government argues this is foreclosed by Ortega-Cordova. Now, petitioner claims and says that the arguments he raises here were not presented to the panel in Ortega-Cordova, but that is incorrect. Once he raised this argument to the panel in Ortega-Cordova and filed a 28J about it, the panel nonetheless went ahead and included that language in their opinion, saying that his argument flouts the clear, unambiguous statutory language. After that, opposing counsel here filed a motion to amend. And in that motion, he requested the court to excise that language from its opinion, and he presented all the same arguments that he presents here, because at that point he had briefed this case. And he even requested the court in Ortega-Cordova to wait for this panel in Perdomo to look at the issue. And the Ortega-Cordova panel declined to do that. They rejected that, and it rejected his motion to amend. So far from dicta, the panel in Ortega-Cordova made it very clear it wanted that language in the opinion. Otherwise, it would have granted his motion to amend if it was actually dicta. But it was not dicta. It was purposely put in that opinion, and the court affirmed that by denying opposing counsel's motion to amend. So we say the argument is directly foreclosed by Ortega-Cordova. And what that leaves is his argument under Belcher. And Belcher, we think, is just an argument, is just a case about legal repercussions and the differences between felonies and misdemeanors. It has nothing to do with the difference in calendar days between 365 days and 1 year. And that's underscored by the fact that some states like California and Washington, for example, have made misdemeanors to be 364 days, not 365 days, just to get around this rule about CMTs. So we think he misreads Belcher, and his argument about the 1 year or more is foreclosed. Unless the panel has any questions for the government.
What about what Virginia says about it?
Is the Belcher argument?
Yeah.
Well, that's what I was explaining, that I don't believe it actually means what petitioner wants it to mean. He wants it to mean that.
What did the Supreme Court of Virginia mean when it said?
It was talking about different legal repercussions between a sentence of 1 year for a misdemeanor on one hand and 1 year for a felony on the other hand. Not there was some difference in the amount of time served in incarceration. So you have a 365-day sentence possible as a misdemeanor, and so you have a 1 year sentence.
Well, what it said is that you could not sentence a person for a misdemeanor for a 1 year sentence, to a 1 year sentence.
No, you could do that. It says that what happened with they remanded because the jury saw that 1 year sentence as a felony sentence, not a misdemeanor sentence. And he said that in the court you saw, as the government explained, said this might be splitting hairs because there is no real difference between the time served that's sentenced, but there's a difference in the repercussions of that. If you describe it as a misdemeanor on one hand, you have quicker ability to build up time served to get early release. You also can serve that time in jail. But if you describe that 1 year as a felony, you lose those advantages. So there was no difference in the actual time imposed or time able to be imposed. It was just what legal consequences stemmed from how you described it as a felony or a misdemeanor. So a misdemeanor sentence can still be imposed for 1 year, but you must label it a misdemeanor. You cannot label it a felony.
You label it, but what you're charged with was a misdemeanor with the maximum sentence, right? 12 months, and you couldn't give a 1-year sentence, right?
You can. I think Belcher still says you can do that. That's why you see they cite the prosecutor's statement that while there's no colloquial difference in the amount of time served, there's a difference in how it's served and legal repercussions. How it's served versus jail versus prison, legal repercussions versus how quickly you can accrue early release. But you can certainly still be sentenced for 1 year in incarceration for a misdemeanor. And if it was different than that, you would see language like you see in other statutes, in other cases, like in California, where it says the maximum punishment or maximum sentence imposed is 364 days. Those states make it very clear that there is a sentence of less than 1 year, less than 365 days. You don't have that language in Belcher. You don't have that language in any Virginia statute. What you have is Belcher just simply looking at the different legal repercussions of describing it as a 1-year misdemeanor or a 1-year felony.
Ms. Gregory, do you have any further?
No.
Ms. Quattlebaum?
No, sir.
Thank you very much, counsel. We appreciate it.
Thank you.
Mr. Weingrad, do you have some time for rebuttal, sir?
Thank you, Your Honor. With respect to Ortega-Cordova, we know the language in that decision was dicta because this court's more recent decision in Chavez did not treat that language as binding. It declined to reach the issue altogether. This court does not customarily decline to reach issues that are already foreclosed by precedent. It says that they're foreclosed by precedent. So I think Chavez itself, which is the more recent decision, and I want to also note Chavez was written by Chief
Counsel,
Judge.
Yes. Given that, Matt, there's been a good debate about whether we're foreclosed by that. I think there's, certainly a strong case that we are. But even if we aren't, we have a panel of ours that plainly considered this issue and wrote about it. And you, as your colleague points out, you wanted them to consider it. You asked them to consider it, and they did. And maybe it's foreclosed, but even if it's not, we have a panel talking very clearly about this. And I mean, we would. Even if somehow we're not absolutely bound, I mean, we would respect, a prior panel who's considered this issue and says the argument you're making is contrary to the plain language of the statute. So, I think there's 2 points. There's one is it foreclosed, and even if somehow you get past that, we still have a panel dealing with this same issue.
Well, yes, Your Honor. To correct the record, I did not ask the panel in Ortega-Cordova to reach the issue. On the contrary, I only notified the panel of the issue precisely so that it would not reach the issue and would allow the panel that decides this case to reach the issue.
I'm not sure that helps you in terms of how important it was to the panel. I mean, maybe that helps you a little bit in arguing we're not foreclosed, but in the issue about whether we should consider it, I mean, again, there's cases where maybe we don't have to follow a prior panel, but we respect our colleagues, and when they talk about something, give it thoughtful consideration. I mean, to me, that is something we should give strong consideration to.
Sure, Your Honor. If the full panoply of arguments that were before this panel were in front of the panel that decided Ortega-Cordova, then sure, I would agree. But the panel in Ortega-Cordova didn't have these arguments. All they had were a series of dueling 28J letters, limited to 350 words, explaining the very outlines of the argument and specifically asking them not to reach the issue. And I think it would set a terrible precedent if this court were to regard as precedent language in an opinion on an issue that was not briefed and which neither party asked the court to consider. Again, I simply no.
Let me say, we can't go into a prior panel opinion which very clearly stakes out a result in which very clearly sets forth its reasoning and addresses the result. And if we can't go behind that and say, well, we think that the panel did not have sufficient information before it, whatever. And for us to be reviewing the adequacy of consideration, the point is, it's not the basis that the panel had before it, it's the actual decision that the panel decided to make. Sometimes panels want a great deal of information before ruling, but other times panels think an issue is very clear on the basis of what they have. But the point is, what in the final analysis did the panel decide to do? And it's pretty clearly on point. What they decided, and in the 28J letter, it put the issue before us. I don't think I was in the panel, but I may have been. I don't know. But at any rate, the whole system depends upon one panel respecting the views of another panel and a prior panel. And there are times when precedent is convenient, and there are times when precedent is inconvenient, but it doesn't matter. It's still a precedent of this court. And so I think institutionally that's what's at issue is our mutual respect for one another, even where we didn't serve on the prior panel. That's all I'm saying.
Okay. Thank you, Your Honors.
We thank you, and
I have a question.
Sure.
Yes,
Chief, leave it. Counsel, do you agree with counsel in saying that Belcher has no consequence to your argument, but how Virginia deals with 12-month sentences versus 1-year sentences?
No, not at all, Your Honor. We certainly disagree with their characterization of Belcher. Belcher holds that a sentence of 1 year in Virginia cannot be imposed for a Class 1 misdemeanor because by statute is subject to a maximum penalty of 12 months. And the court explained that the Assembly intended 12 months and 1 year to mean different things, and that a sentence of 1 year falls outside the permissible statutory range for a misdemeanor. And again, Belcher did not solely rely on how these sentences are carried out. Belcher said that a sentence of 1 year is, quote, beyond or outside the statutorily permitted range, and the trial judge should not have reduced the 1 year sentence to 12 months.
Right, that's exactly what I thought it was too.
Yeah.
Not about how you serve and those kind of things. Go ahead. That's all I have. Thank you.
Thank you, Your Honor.
All right.
all right, we thank you, and we appreciate very much your arguments. Sorry we can't shake your hands and tell you so, but appreciate your being here. And now we will move directly into our third case.
And may it please the court. This case turns on one question. Did Mr. Zeledon's nonviolent escape from ICE custody years after his immigration court proceedings closed obstruct a pending proceeding being had before an agency? The answer is no, because at the moment of his escape, there was no pending proceeding before an agency to obstruct. The government puts forward 3 theories for what could constitute the relevant proceeding. First, that the immigration court proceedings, which concluded in 2019, were in fact pending indefinitely until a different agency, a law enforcement agency, exercised its discretion to enforce the final removal order. Second, that ICE removal operations, day-to-day police activity, are standalone proceedings being had before ICE. The district court did not rely on that theory. Third, a theory that was not even indicted and that the district court did not consider, that Mr. Zeledon's own motion to reopen initiated a new standalone proceeding that was somehow obstructed after his motion was denied. Each theory is fatally flawed and cannot sustain Mr. Zeledon's conviction.
Well, one of the things is that many times enforcement proceedings or enforcement of an ICE removal operations, that doesn't all take place in a day or a week and a month. It sometimes takes a while to enforce a removal operation. And in this case, you were talking about someone who escaped, and it's the obstruction itself that can lengthen the enforcement period. So why would we adopt a view of obstruction and proceeding that placed an incentive on someone to escape and hide? And if you can only hide and escape or obstruct something successfully enough such that the period is delayed, then we should regard the whole proceeding as defunct, because the proceeding, by its very nature, sometimes takes a while to effectuate, and particularly when someone is engaged in an act of obstruction, escape or hiding or any kind of other act of obstruction, it's likely to lengthen the proceeding. So I'm just wondering why we should accept your first theory there.
3 points, Your Honor. There's no incentive. There are other statutes that cover this kind of behavior. Second, the immigration court proceedings were not pending. There was no interference with that decision-making process. There is no link.
It doesn't, but that's, again, a proceeding doesn't depend on whether some adjudicatory process is pending. The enforcement itself, just like investigation can be a proceeding, the adjudicatory process can be a proceeding, and the enforcement can be a proceeding. There are three different things, as I understand it, that can be proceedings, and what we have to look at are the powers that are conferred upon ICE. I realize ICE is an unpopular character these days. It's an unpopular institution, but we've got to go by the law, and there was a broad set of powers conferred on ICE, including issuance of subpoenas and administration of oaths and considering evidence. So the enforcement itself can be a proceeding, even if an adjudicatory proceeding is not pending. That would be a very truncated view of proceeding if we were to adopt that view of it.
Your Honor, law enforcement is not a pending proceeding being had before an agency. Here, ICE removal operations are not pending proceedings being had before ICE. That contravenes the word proceeding, that contravenes the word before. Case law has long...
Where's the word pending now?
In 1505, the key phrase is pending proceeding being had before a federal agency. Before is a particularly troublesome word for the government. It's a spatial metaphor in front of, and in 49 different provisions of the U.S. Code, it's used 49 times. DC District Court has counted around 52. Each kind indicates the kind of adjudicatory or quasi-legislative decision-making process that is convened. And I grant it that there are some investigations that may also fall into a 1505 proceeding. But here we have mere police activity. Case law has long drawn a red line excluding mere police activity from the scope of 1505. We have Kelly, Ramos, Rice. This is a consistent theme dividing what might be a formal investigation of some kind with the day-to-day routine ICE removal operations that are at issue in this case. The key here, the reasoning, is about the decision-making process. Routine law enforcement activity is not the kind of decision-making process such as interfering with witnesses or in a hearing or in a trial that 1505 protects. In the government's interpretation is a sprawling one. This creates a sprawling statutory scheme where there's constant pending proceedings with no limit on what that means. That would criminalize.
Why doesn't the government's view underscore the importance of a continuing sequence, which is comprised of three basic parts: investigation and adjudication and enforcement. And it's possible to proceed. Many courts have adopted an expansive view of the term proceeding because it looks at it as a sequence involving these three component parts, as I've mentioned it to you. And Congress had the desire of wanting this procedure as a whole in all of its component parts to proceed in a way that was seamless and unobstructed. And that's what was bothered. That's what was the problem was here. And I worry that your view of things is sort of puts a premium on escapes and obstructions of all different sorts in the face of a congressional desire to have a proceeding be continuous from beginning to end and to have the immigration process proceeding in an unobstructed fashion. And what you're trying to do, I think, runs counter to what Congress wanted to do. It seems to me you want to chop it up into little pieces. And Congress was looking at that as the process as a whole.
Your Honor, it sounds like you're concentrating on whether the immigration court proceeding pends indefinitely until there's an enforcement of the removal order by a different agency. That is incorrect for three reasons. First, Congress has indicated in several statutory provisions that the immigration court proceedings come to a conclusion when the immigration judge issues his order and there's a final order of removal. I can point you to those provisions, 1229A, distinguished from 1231, which is the removal period and what happens there. Congress is clear that in this context, it ends with that decision of the immigration judge.
Second, I understand that, but when the word proceeding appears in 1505, Congress didn't say an official proceeding, or it didn't say an adjudicative proceeding or an adjudication. It used a term that it refused to cabin by saying official or adjudicative, or it could have put some limiting adjective in front of the word proceeding, but it didn't put a limiting adjective in front of the word proceeding for a particular reason, and that was that Congress wanted to preserve and safeguard the immigration process from obstruction, of which escape would be a prime example of an instruction. And what I'm saying is proceeding is a broad term. It could have been cabined, it could have been narrowed, it could have been linked to some pending adjudicative hearing. But I'm worried that you may be trying to rephrase the statute and to say some pending adjudicative proceeding or some official proceeding or whatever. And I'm just not sure that that's either what Congress intended here or the way the statute reads.
If I may
Counsel,
make,
can I jump in? Well, answer Judge Wilkinson. I have a question I'll follow up with after that.
Of course, Your Honor.
I've finished, Judge Quattlebaum. You go ahead.
If I may answer real quick, this court should not draw a distinction between official proceeding in 1512 and 13 and the terminology here. The government, in a different brief in Lopresti, has agreed with this. Congress has defined official proceeding to include a proceeding being had before a federal agency. You can replace those two in the statute. Okay, second, here we think the best definition is administrative proceeding that gives that takes into account the context here, a proceeding before an agency. That's a hearing, inquiry, investigation, or trial before an immigration agency, usually adjudicatory in nature, but sometimes quasi-legislative. And there's no gap here that's going to be created. There's 1253, which covers hampering the execution of removal order. The government has simply chosen the wrong statute in this case.
So, Counsel, I was going to bring up 1253. If proceeding covers the conduct here, does 1253 have any real purpose?
Your Honor is absolutely right that the government's interpretation creates surplusage, not only with 1253, but may I point you to 1510A, which is interference with a criminal investigation. There, it's the same penalty, 5 years, and it criminalizes not interfering with the information given to a criminal investigator. There'd be no reason under the government's interpretation to have that provision. Same penalty, interfering with a step in the agency process and law enforcement. In fact, there's a pending, just to put a pin on it, there's a pending law that Congress is considering that would amend 1510 to not only cover criminal investigations, but to cover, quote, immigration enforcement operations. That's just an example of how plain meaning operates here. Immigration enforcement operations is not a proceeding, and that's just plain meaning of proceeding, plain meaning of pending, plain meaning of being had before an agency. It sounds very odd, as Ermoyan, a Ninth Circuit case, points out, very odd to talk about immigration removal operations being had before in front of ICE. That doesn't make sense. When you read the whole phrase in context.
Well, what about the powers conferred upon ICE, which are the power to issue subpoenas, administer oaths, take and consider evidence, and the like? That I mean, all I can say is that I don't think we can't mix and match. Well, does this statute cover this? Does this statute cover this? Is there a loophole here? I think we just have to look at the language of each particular provision in each particular statute. And what concerns me is that Congress could have narrowed this term proceeding if it had wished, and I'm just not sure it's our function to try to do that and to add qualifying words that Congress did not include.
There's absolutely no qualifying words here. The government, this is a case unlike any other case that's been considered, which involved informal investigations before an adjudicatory proceeding. This is talking about indefinite law enforcement, mere police activity that happened years after the relevant proceeding. The government is absolutely expanding here, and Fisher, Marinello, all asked us.
Are we supposed to go case by case by case and see what the length of the years were? How do we draw that line? Is it, is it a month, 2 months, a year, whatever? I don't know. Your whole point about the delay would indicate, it seems to me, to involve the courts, it seems to me, in a line drawing process about when is a delay sufficient to make something not as a proceeding, and when is a delay relatively short? I don't get that.
I know I'm running out of time, Your Honor. Delay has nothing to do with this case. Congress has defined the conclusion of immigration court proceedings in its statutes. The immigration court proceeding was not pending. Separately, ICE removal operations are not pending proceedings being had before ICE. That contravenes many cases talking about the difference between mere police activity and an investigation. To get to Your Honor's point about subpoenas, yes, agencies sometimes have subpoena authority. That doesn't mean anything that they do, any step they take automatically qualifies.
Do you disagree with the Third and Ninth Circuit opinions that said that agency investigations qualified as proceedings, despite the agency's absence of any kind of adjudicative power?
I think a court can absolutely look at evidence to see when there is the kind of decision-making process, like an adjudicatory or quasi-legislative decision-making process that counts as a 1505 proceeding, and that subpoena power
I'm asking you about the Third and Ninth Circuit opinions, which defined an agency investigation qualified as a proceeding, notwithstanding the agency's absence of any kind of adjudicative power. And what worries me is that you're trying to make the term proceeding, you're trying to make it judicial in some way. And I don't see that. But at any rate, you can, you've got some rebuttal time, and be happy to hear from you with respect to that.
Thank you, Your Honor.
I didn't mean to cut my colleagues off. Judge Gregory, do you have any questions of Ms. Moran?
No.
Adeline, do you have any questions?
No, sir.
All right, Mr. Day.
Yes, Your Honor. May it please the court. ICE removal operations qualify as Section 1505 proceedings because they require agency investigations. You can take, for example, the facts of this case. When the defendant escaped, ICE had to investigate. Where was he? How did he get there? Who, if anyone, helped him? And circuit courts across this country have uniformly found that agency investigations of this sort qualify as 1505 proceedings. Judge Wilson.
Mr. Day, go ahead, Judge Quattlebaum, go ahead.
No, I'm sorry, Judge Gray. I'll follow you.
No, you seem to equate procedure with proceedings. What you listed out, there are procedures to try to look for someone, to what their whereabouts are, and those things. Those are procedures. They're enforcement procedures, but that doesn't make them proceedings before in the agency. You equate procedures with proceedings. Isn't that right? Is that what you're doing?
Your Honor, I think what I'm doing is looking at the plain text and the plain meaning of the
Well,
word.
the plain text says proceedings, and I'm saying, I want you to answer my question. Aren't you saying that procedures equate with proceedings? I'm talking about the text too.
I'll be honest, I haven't considered the meaning of the word procedure here, but
what you just said were procedures of investigating where they are, finding where they are, and then making an arrest. Those are procedures. They're law enforcement procedures that they do all the time. But proceedings, before, it has a meaning and an understanding. It's not rocket science. They're not the same, are they?
Well, Your Honor, I think if you're getting to the distinction between mere police activity and a proceeding, courts have repeatedly looked to agencies' subpoena authority. And in this case, ICE not only had subpoena authority to compel testimony and gather documents, but it also had the authority to administer oaths. And that's
so counsel, on that point, I think I think you have a point there. Judge Wilkinson referred to this, that ICE, has the authority to conduct what would be proceedings through subpoena power and stuff like that. But just because it has that power, does that mean everything it does is a proceeding? So it seems to me the question, and I guess here this argument is you're is the argument that the ICE removal efforts are a separate proceeding from the prior proceeding. And on that point, don't we have to look not at what ICE's overall abilities are, but whether what was going on at this point in time was a proceeding or not?
Yes, Your Honor, I understand your question. First, does everything that ICE does count as a proceeding? I think the answer to that is what's charged in the indictment. And what's charged in this indictment is the removal proceedings being conducted by DHS and ICE. So that's what this defendant was charged with. And put differently, those are ICE removal operations. ICE unequivocally has a subpoena authority to conduct removal operations, to issue subpoenas to enhance its investigations to find fugitives. So if that answers Your Honor's question.
Yeah, I'm just concerned or asking about, I mean, you didn't issue any subpoenas, you didn't place anyone under oath in this matter. And it feels to me like this is more of a carrying out the removal. And I'm just trying to, and maybe that's enough to be a proceeding, but it just doesn't feel like it has any of the earmarks of it. Judge Wilkinson's questions earlier seemed to be geared at whether the Attorney General's proceeding that resulted in the order, we were continuing that on. You seem to be saying this ICE, deportation efforts is its own proceeding. And I realize you made both of those arguments below. You're entitled to make both those arguments below. I'm just, on the second argument at least, it seems like, had you been in doing something like, administering oaths or issuing subpoenas, and if that was really all part of what was going on, you might have a point there, but the record doesn't seem to be saying that's what you were doing.
A couple points in response, Your Honor. First, I just want to talk about the facts in the Ninth Circuit case, the Kirst decision. That was an NTSB investigation to a plane crash in Alaska. NTSB has no adjudicative authority. In that case, the NTSB did have the ability to issue subpoenas. It had not. That was clear on the record that the NTSB had not issued any subpoenas in that plane crash investigation. But the Ninth Circuit said the authority to do so, that is enough, is the phrase the Ninth Circuit looked to.
Do we need to go that far? I mean, in this instance, as I understand it, ICE was trying to enforce a removal order. Is that correct?
Absolutely, Your Honor, and that gets to
that's what's important to me. It's not a question in the abstract that this is a proceeding or this is not a proceeding, or what abstractly ICE has the power to do. The question is what it's doing in this case, and what it's doing in this case is exercising enforcement authority. And as I understand it, that rather than any abstract blanket view that everything ICE does is a proceeding, when ICE is acting and operating as part of the judicial system and enforcement of a court order, we as courts depend upon the executive branch to enforce our orders, even in the basic slip and fall case or doing anything. Without executive branch enforcement, we are substantially impaired. We can't enforce our own orders. And you don't have to have a broad position here. You can have a view that ICE is enforcing a court order, and that the investigation that precedes the adjudicative act is part of the proceeding. The adjudicative act, the hearing, is part of the proceeding. But you can't just cut it off arbitrarily at that point and say, oh, you can issue the order, but the enforcement of it can be obstructed. That's going to be a terrible precedent as far as the implementation of basic removal orders is concerned. You know, if ICE is going into Minnesota and tragically oversteps and shoots somebody, that doesn't mean that it's a proceeding, but because every time ICE oversteps, they're not, you know, that's not a proceeding. But if there's a removal order, and we're talking about enforcing a removal order and obstructing the enforcement of a removal order by escaping here, there, and hiding here and there, that's a different can of fish, isn't it?
Absolutely, Your Honor. And Your Honor's question goes to the Ninth Circuit's decision in Hopper and the Seventh Circuit's decision in Sempner. Those are directly on point. These cases deal with the enforcement efforts by agencies. In fact, both those cases, the agencies were attempting to enforce a U.S. District Court order. In the Seventh Circuit case, Sempner, there was a SEC litigation that resulted in a district court issuing a temporary restraining order that frees certain assets. The defendant then obstructed by trying to conceal those assets. He was charged.
My friend Judge Wilkinson brought this up about Minnesota, since he brought that up in the question. That is, and you said this statute, if read like you want it to be read, is not limited to the person who's the subject of the search and the arrest. It's anybody who impedes it, right?
Anybody who impedes a targeted enforcement operation in this context.
So that means that so a person's standing around looking at it and they're doing something and ICE feels that that's impeding them, they could be charged with this statute, right?
Well, I don't think that if the standard would be if ICE feels that it felt that they were impeding them.
Why wouldn't it be? Who determines what impeding is then?
Well, Your Honor, the words impeding require some sort of...
Who determines what impeding is?
Ultimately, I think a jury would determine if
a jury doesn't determine it at all. There's no juries out there adjudicating those cases with ICE that pick it up. No court. Have you seen any cases that the court is coming in and determining whether or not? No. ICE would determine whether it's impeding them, right? Because you're saying that that's a proceeding that's before an agency. You can't have it both ways. Once you go down that slippery slope, and the slippery slope is not what Judge Wilkinson is talking about, that courts can't enforce their orders. No, you can enforce your orders. That's no question. It's ironic that the person you're looking for is going to be leaving the country. So there's a lot of enforcement. So it's nothing, no slippery slope is lost if this statute is overreached. But the question is how much that it extends to people who may be standing around looking. So I don't think you need to be here. So my question is, who determines, since you said this is a proceeding before the agency, the arrest itself is the enforcement. So if you determine that's impeding, what ICE determines that, right? Under this statute, the way you want to read it. Because I don't know if anybody, because there's nothing before a court or the agency at all. It's just ICE sends you, and I think people are just whisked away, 1,200 miles away, for example, from that point and gone, and, either leave or detained. There's no proceeding. It's just an arrest. And it says that if we think that you're impeding, then you could be charged separately under this statute. Correct? I mean, I'm just saying, isn't that right?
I want to focus on the facts of this case where
I want you to focus on my question.
Okay, I was just trying to put it in the context of which
you just said, I want to focus on something. I want you to answer my question.
Yes, Your Honor. And let me try it this way. There's an order of removal that was issued by immigration court that then authorized immigration officials, in this case ICE, to arrest this defendant.
Yes.
And so this is all happening under statutory and regulatory authority. And so
yes,
I to Judge Wilkinson's question, I think enforcement...
Keep on going. I thought you're doing a good job. Stand, as my mom used to say, every tub got to stand on its own bottom. you're here now. You tell me. Finish your. I'm following you. Go ahead.
I- Enforcement of those of the removal operation is both a standalone ICE proceeding. I understand the court's concern about that theory, but it is also a
Theory?
continuation of the
Did you
immigration
say
court
theory? Did you say theory?
argument, Your Honor. I apologize.
No, I don't know it was a theory at all. I mean, Judge Wilkinson brought it up in terms of Minnesota. So what I'm saying is that that's you're arresting people, right? So if you go ahead, I don't want to interrupt you. You were answering my question. Go ahead.
If ICE is conducting a targeted removal operation, in that case, the arrest of a non-citizen who's subject to a removal order, they are enforcing and participating in a proceeding that is
This has all got to come before a court eventually, whether it's a magistrate judge or whether it's a jury. You can't convict somebody of a 1505 proceeding without going through the normal processes of adjudication and a prosecution and a jury verdict and everything else. It's no different. The question is before us is a really straightforward one. It's a simple one. And that is, do we align ourselves with the Third and Ninth Circuit in saying that that an agency's investigation or what have you can qualify as a proceeding in the absence of an adjudicative power? And what is critical here is that not that ICE is being given some blanket open-ended power, but it's trying to enforce a judicial order, and frustration, and that is a proceeding. Enforcement is a part of a proceeding. Investigation can be part of a proceeding, but particularly, I think there's even a stronger case that enforcement is a part of a proceeding because we don't enforce our own orders. And ICE is the one to enforce that order. And if it can't enforce the order, if it can't enforce a judicial order, that's an obstruction of a proceeding. But you don't have to go broad to get to that point. You can simply limit it to the point where ICE is engaged in the function of enforcing a judicial order and a judicial decree. And if that is not a proceeding, I really do not understand what is, because you cannot conceive of the judicial authority without the enforcement authority that the executive branch brings to the picture. Because in the absence of the executive branch's assistance with enforcement, our powers are rendered nugatory.
Your Honor, the Seventh Circuit put it this way: whenever an entity acting for or at the direct request of an agency has been obstructed, the agency itself has also been obstructed. And so when applying that principle here, when ICE acting at the request of the immigration court, when ICE is obstructed, the immigration court is also obstructed. And so the enforcement efforts at issue in the Sefner case from the Seventh Circuit are directly analogous to ICE's actions here. Yes, Judge.
Counsel, can I follow up on that? Yeah, that makes a lot of sense to me, kind of in practical terms that, that if something happens to an order, that if you're doing something in response to an order, it affects it, it obstructs it. I guess the part, I mean, the part that I'm trying to grapple with, it seems like under the statutes that apply here, the order of removal closes the administrative proceedings. And that's why the petitioner here a couple times had to move to open them. If you have to open them, they were closed before. And and I'm just wondering, Judge Wilkinson makes some very good points that I tend to agree with, but my concern is whether if the statute says the proceeding is closed, it's not a pending proceeding, just by the way the statute goes. Help me with that, and number one. And number two, I don't think that means people have carte blanche to then just escape like this individual did, because 1253 stands ready to be a basis to convict them. So I guess those are my two questions. Is one, I mean, no matter if this, I necessarily like the result of it, does the way Congress has said procedures close matter here? And doesn't 1253 stand ready to be an obstacle to this type of thing happening?
So the argument Your Honor's concerned about here really gets to, does the plain meaning of the word proceeding apply, or do we apply some sort of technical, statutorily defined meaning of the word? And courts have been uniform in applying the plain generic meaning. In the Parad case in the Southern District of Florida, the defendant there made a very similar argument that the SEC action that he had obstructed was not a SEC proceeding as defined by the SEC. The court said nothing about these SEC regulations even purports to address what types of SEC activity qualifies as a proceeding under the text of 1505. And I think the inverse is also true, that the text of 1505, nothing about it purports to adopt or incorporate by reference the statutory rules or definitions of proceeding under the Immigration Code. And the Fifth Circuit has echoed that conclusion in the Rainey case, where the defendant obstructed a House subcommittee's investigation, which is the neighboring provision in 1505 here that references obstruction of a House committee. He argued that under House rules, the internal House rules, he didn't obstruct a House committee, just a subcommittee. The Fifth Circuit said, no, we're not looking to Congress's internal rules about what defines a committee in that instance. We look to the generic meaning of the word. And so this ground has been tread. And so the plain meaning of the word proceeding, I think in this case, it means that the immigration court proceedings end at the conclusion of the goal they sought, either the removal of the defendant or he obtains relief from removal. That's my response to your first question. I am seeing that I've just run out of time, but I'm happy to respond to the 12.
Let me, Judge Quattlebaum, did you have any further questions on this?
No, I just only just simply, I mean, I know you're running out of time, but I mean, you don't deny, do you, that 1253 criminalizes the conduct that, you know, the petitioner here, you know, engaged in?
We absolutely could have charged 1253 in this case. A couple points. 1253's guidelines are 0 to 6 as opposed to 18 to 24. We thought this defendant's conduct required, or warranted rather, a higher set of guidelines. 1253 also uses the word mens rea for willful, which is likely deliberate or intentional conduct. And 1505 requires something corruptly, which is an improper purpose. And so 1250
it's pretty hard to escape, you know, without it being willful, isn't it?
I agree, absolutely, Your Honor. And that's why I agree we could have charged it here, and inevitably there's going to be some overlap among not just.
I don't think that means you couldn't do this one if it qualifies. I just wanted to make sure we understood that regardless of the view of 1505, the conduct is criminalized under other statutes.
I agree with that, Your Honor. Yes.
I have two questions with respect to that. I don't think we can compare statutes and say, is this other statute that may cover the conduct? Because in any prosecution, the prosecutor has an option of selecting counts. And it's very often that one statute, that someone could be prosecuted under one statute. It might have been prosecuted under another. But I think the job we have is to interpret the statute before us and not how it might fit in with other statutes. We have to look at the statute that is right before us and not how it fits or doesn't fit within another prosecution, because that is a different case. It is a different case. And I don't think it's fair to say that a case is closed until the judicial order is enforced. A lot of times people would issue an order to dismiss and say, case closed, but there are further proceedings involved. There are collateral attacks. I mean, the district judge will say, here's the order of dismissal. The case is closed. But of course, we know that it's not closed. We know that they're going to be appealed. We know that there are going to be collateral attacks. We know that there are going to be consequences of all sorts. So it seems to me if you leave a judicial order that's handed down but is never enforced, then in any real sense, I don't see how closure has been brought about. And the point that I would make is that we're not seeking, and I think people are concerned about it, we're not seeking, as I understand it. And if you're adopting a broader argument, then I have reservations. But we're not seeking some kind of blanket authority on the given to ICE. If they go the 1505 route, a jury will make the determination of whether there's an obstruction. That rests in the ultimate analysis with the judicial process and with the jury. It doesn't rest with ICE. And if they think it does, then they're going beyond the law. But the ultimate decision lies with the jury. And we have two circuits out there, the third and the ninth, that I think accord with what you're arguing here, Mr. Day. And that is that we can't artificially construct different barriers around the different components of the immigration process. We would be carving it up to a degree that Congress did not envision, and we'd be constructing barriers at each step of the way. But this is not a situation, and I'm not, Judge Quattlebaum said you have two theories, but I understand you're not before this court arguing for the broader theory. You're arguing for the narrower view, aren't you?
I have three theories, just to be clear. First, that ICE removal operations qualify, and if the court it doesn't like my frontline theory, I'm very happy with my fallback theory. My second one here is that the immigration court proceedings remain pending until the removal of the defendant or obtain removal. I have a third theory that I like that we haven't talked about the motion reopen proceedings, that I think even if we're in the context of the internal rules and definition of the immigration court, this court's precedent and Johnson and Serrani, there's no way around that the proceeding remained pending during the 30-day clock that hadn't elapsed when he escaped. And so those are the three theories, Your Honor.
Judge Gregory, do you have further questions?
Well, Mr. Day really didn't say anything, and I don't think it's appropriate for me to respond to what you said over the last 5 minutes. So, no.
Judge Quattlebaum?
I'm fine. No other questions. Thank you, Mr. Day.
Thank you all.
Ms. Moran, you have some rebuttal time.
Thank you, Your Honors. I want to be very clear that our theory is not in tension with the Ninth Circuit's decision in Kirst or the other investigation decisions. Our theory does not turn on the possession of adjudicatory power. In Kirst, That was an investigation that qualified as a 1505 proceeding because they were interviewing witnesses. The process, NTSB was convened to decide what the facts, circumstances, and cause or probable cause of an aircraft accident were. That absolutely fits the definition of an administrative proceeding, as in Black's Law Dictionary, a hearing, inquiry, investigation, or trial before an administrative agency, usually adjudicatory in nature. Okay, they were adjudicating, they were making decisions. That definition does not include enforcement. I want to be very clear. General enforcement is not a proceeding being had before an agency. Okay, there is absolutely no gap created by our theory. And the idea that court orders are not going to be enforced because if we win, backfires spectacularly on the government. Congress has put this into the text. There's a difference between 18 U.S.C. 1503 and 18 U.S.C. 1509. One is about the judicial proceedings, administration of justice. The other one is about obstructing court orders. And you see the exact same parallel in this instance. The immigration court proceeding closes. There's no obstruction of that decision-making proceeding versus 1253, hampering the deportation, the removal of an immigrant. So we have no gap here. The government puts forward a completely unprincipled, no limiting principle on 1505 proceedings. Any step an agency takes with a targeted objective, that will include any kind of enforcement action in any setting. There has been no facts here showing.
There has to be an outstanding court order. You say, well, we can distinguish a situation where an agency is in an investigative mode, and we can distinguish a situation where we're talking about an enforcement proceeding. I'm not sure, frankly, how you draw that line. I think that enforcement is every bit as crucial a part of an agency proceeding as investigation. And it strikes me as very artificial to say, well, investigation is a proceeding, but enforcement is not a proceeding. It's all part of a continuum. You have, any case, you have a U.S. Attorney's Office working something up. You have a court that decides it. You have executive branch officials enforcing it. And those are all part of a single continuance. And for us to say, well, investigation is part of a proceeding, but enforcement is not part of a proceeding, that just seems to me the definition of artificiality.
Your Honor, in your own Sutherland case, you drew a distinction between obstructing an attorney's office investigation and obstructing grand jury proceedings. So no, it's not true that like any law enforcement activity that's just mere police activity. We cannot look at proceeding in isolation. It's pending, the key phrase is pending proceeding being had before an agency. And the government's point that we're just ignoring the definition of proceeding doesn't make any sense. The government has to show that our client obstructed a specific proceeding. So you not only have to consider the 1505 definition of proceeding, you have to consider when the particular proceeding actually closed. To say that immigration court proceedings pend indefinitely until the executive branch, which has
how do you define indefinitely? There's a court order out there. They're trying to enforce a court order. And how do you define the phrase indefinitely? You keep saying, well, you say this case doesn't involve delay, and yet you keep using the word indefinitely. Well, I don't know what indefinitely means, and all I do know is that any time period is extended by the fact of the escape.
I understand the confusion, Your Honor. So I'm trying to contrast the word pending, which means remaining, awaiting to be decided. That's a key term, and the plain meaning limits the phrase here. And so an immigration court proceeding was not remaining to be decided, it was closed. And my point is that to include the enforcement of a removal order creates this absurd result, essentially, that the executive branch does not ever have to enforce that removal order. This is a different agency, never has to be removed. That's the president's exercise their discretion all the time not to enforce these. And so to create these indefinite proceedings that contravenes many statutory contexts, including judicial review of removal orders, and would create a dangerous precedent across the country. Any kind of resistance to law enforcement is going to count as
we have our own precedent here in the Mitchell case where we emphasize proceeding is a comprehensive term and that it involves all steps and stages from inception to conclusion. And it seems to me we just, chopping it up into artificial little parts. Anyway.
We're consistent with Mitchell. We're talking about when is the conclusion.
Excuse me. If Judge Gregory has questions for you, then we will continue this. And if Judge Quattlebaum has questions for you, then we will wait until their questions are answered. Judge Gregory.
I have no question really, but in terms of the point counsel makes that not only says pending proceedings and being, but a key word too is had, is being had before. I mean, that's what it's before them a proceeding. It's not just enforcement. And as to how long it would last, I guess on this reading is if the person is 95 years old and haven't been caught yet, and it started when they were 25, it could go a long time. It would still be a proceeding being had before the department. I think Congress meant to have those limiting sort of temporal meanings in there for a reason and for being a proceeding. And so that's all.
You're absolutely right, Your Honor. Being had is a specific time frame. Fisher talks about how these are particularized obstruction statutes targeted to specific circumstances. And that is being had is another, that present tense verb is yet another indication that this has a limited particular circumstance.
Judge Quattlebaum, do you have further questions?
No, I do not have any other questions. Thank you.
All right, we thank you both, and we appreciate very much your being before us. And I think you may be, Ms. Moran, you may be pro bono, and so I would extend a particular thanks to you for taking the case, and we appreciate the able manner in which you've argued it. We'll have the courtroom deputy please adjourn court. I think we're at the point of being sine die at this point.
This honorable court stands adjourned. Sine die. God save the United States and this honorable court.
All right. We appreciate